creation of constitution, having complete authority and domain over the process of election. There is a provision in the constitution, article 2183, which says that it is the election commission who has been vested with the duty and prerogative to conduct general elections or by-elections in the country, and to ensure that elections are conducted impartially, fairly, transparently, justly, and all corrupt practices are guarded with. That provision has also been interpreted by the courts in many cases, and every time it has been resolved that it is the election commission which in its best judgment shall ensure that elections in the country are conducted in a fair, free, transparent manner. So the controversy started from the point when the election commission sought date for appointment of elections. There is confusion that in case the assembly is dissolved upon the advice of the prime minister, who shall appoint the date, because governor, if it is not instrumental in the dissolution, like in the Punjab, the assembly was dissolved on the advice of chief minister of Punjab. The relevant article says that upon the advice, the governor shall dissolve the assembly, and if he fails or if he considers not to dissolve or if he is inactive, then after the lapse of 48 hours, assembly would be deemed to be dissolved. So this is the point of controversy from where the litigation Pandora was open. The governor Punjab did not acted upon the device, and the assembly was dissolved as per the flux of time, like on the passage of 48 hours. So the first round of litigation was regarding the fixing of date, that who to fix the date. The matter was brought before Lahore High Court. Lahore High Court, after hearing the parties, directed the Election Commission to appoint a date after consultation. And the governor filed an appeal in the Lahore High Court, which was pending. In KP, the governor was in process of consultation and a writ petition was also pending in KP. When a two-member bench of Supreme Court of Pakistan, if you may recall, while hearing a petition regarding the removal or the transfer of a police officer, they took it so seriously and they considered that elections shall be held in a stipulated period, which is 90 days, and the time was passing through. So the bench headed by Justice Ijazul Hasan, flanked by Justice Mazahir Naqvi, referred the matter to the Chief Justice of Pakistan to examine it and, if appropriate, take suo motu notice by constituting a bench. Pursuant thereto, a 9-member bench was constituted by the Chief Justice of Pakistan, which assumed hearing. In the initial hearings, 2 honorable members passed judicial orders. They recorded their separate opinions, and they said that since the matters are pending before the high courts, and since 184.3, constitutional provision 184.3, which vests jurisdiction in the Supreme Court to take suo motu notices or exercise its own constitutional jurisdiction, is a concurrent jurisdiction with the high courts. So the case was not found to be fit for exercise of that jurisdiction, and it was found appropriate, if the high courts seized with the matter already, may continue with the proceedings. They recorded their separate opinions. In the meanwhile, the bench was reconstituted by the Honorable Chief Justice, because meanwhile an application was filed by political parties requesting that 2 honorable judges had already expressed their opinions, and there were certain other backgrounds regarding their conduct as judges. So they may recuse themselves from the proceedings, which is not something which is happening first time, I would say. We have experienced so many occasions where objections were raised or request was made to the honorable judges that they have some conflict of interest, or they have expressed opinion already in that case. So they may recuse. 2 honorable judges who initially referred the matter to the Chief Justice, they voluntarily recused themselves. Meanwhile, 2 honorable judges had already expressed their opinions through separate orders. The matter was then placed before a bench of 5 honorable judges of Supreme Court, and at the conclusion of hearing, the one view is that the petitions were accepted, like the case was disposed of with majority by 3 against 2, directing the Election Commission to fix date in Punjab in consultation with President of Pakistan and date in KP in consultation with the Governor of Khyber Pakhtunkhwa. However, in the same order or judgment, the two honorable judges concurred with their two learned colleagues who had already dismissed those petitions. So that is the point from where this legal controversy actually started. The government was on record, I being the law minister and the Attorney General, the then Attorney General for Pakistan, we expressed our view soon after the announcement of decision that those proceedings were disposed of or dismissed by a majority of 4 against 3, because two honorable judges said that these petitions are not maintainable, lack jurisdiction, and the matters be placed before high courts for appropriate orders. Those two opinions were concurred to, followed by 2 judges sitting in the 5-member bench, and they put footnotes as well to clarify the situation that under the dispensation, under the scheme of law, under the court practice, such orders can be passed. So it was a decision taken by the government and many segments of the lawyer community and the society as a decision dismissing the petitions and referring the matter back to high courts, which also the proprietary demand that if the independent high courts were seized with the matters, they should have proceeded with the same. However, the decision given by 3 honorable judges, the Chief Justice and 2 other members, that decision was presented as order of the court. So once again the controversy erupted, the which decision to be acceded to. The government took the stance, the parliament as well, that the decision is of the 4 judges, which is majority decision. When matter was re-agitated before the Supreme Court of Pakistan through petition filed by Pakistan Tehreek-e-Insaf, their speakers of the outgoing assemblies, at the outset this objection was taken by the principal law officer, the Attorney General for Pakistan, reminding the Honorable Court that a larger bench may kindly be constituted to resolve this controversy first, because it is a jurisdictional important legal question which is to be answered by a larger bench. Larger bench means they requested for full court, and in past we have at many occasions saw that the entire Supreme Court sat together in a full court bench and they decided the matters, especially when the matter is of some national importance. That request was not acceded to. The political parties who were previously part of the proceedings, which include Pakistan People's Party, Pakistan Muslim League N and Jamiat Ulama Islam, they also filed applications that they be included as party because they did have the parliamentary presence in the dissolved provincial assemblies. And if it is a question of public importance, if it is a question of enforcement of fundamental rights, it is the fundamental right of the party, political party, to take part in the process of election. And they also represent a large number of their members. Those constitute public at large. Surprisingly, their applications were not entertained. They also raised certain objections, requested for constitution of a full court, barring those 2 honorable judges who had already voluntarily opted to recuse. But despite all that, the 5-member bench resumed hearing. In the meanwhile, another order was passed by a 3-member bench of Supreme Court of Pakistan, headed by the senior Pune judge of the Supreme Court, Justice Qazi Faiz Isa, who handed down a verdict that since the manner in which the jurisdiction under 184(3) of the Constitution, which is the suo moto or original jurisdiction of the Supreme Court, that manner has been under discussion in full court meetings and by the different segments of society, including the political factions and the law societies or the bar councils, bar associations. The judgment also directed the office of the Supreme Court that matters pending before the Supreme Court arising out of 184(3) proceedings may also not be listed for hearing or may be halted in the meanwhile. And a full court meeting was desired by the bench, that a full court meeting of honorable judges be convened to resolve this issue. Such meeting was also convened back in 2019, and these issues were discussed for framing of rules, but unfortunately thereafter no progress was made. That judicial order was also overturned by an executive circular issued by the registrar office, upon which a show cause notice was also issued to the registrar of the Supreme Court that why should he not be removed, and the displayer was shown by the head of the bench. Confronted with the situation one after another, two honorable judges, part of five-member bench who was seized with the matter, hearing the case, they decided to leave the bench. That they decided in their own wisdom that they should not sit on the bench unless until the orders of the judicial orders of three-member bench are not complied with. They actually, by dissociating themselves with the bench, they acknowledged, and not only acknowledged, but they followed the diktat laid down by, or the orders passed by a three-member bench headed by the senior punier judge, that all proceedings arising out of 184(3) may kindly be halted in the meanwhile. At that juncture as well, the request was repeated by Attorney General for Pakistan that there are two serious constitutional legal issues involved in the case. One, whether it is a judgment by majority of 4 against 3, or the previous judgment was by a majority of 3 against 2. This matter, the very important constitutional question, needs to be addressed by the court, and for that matter, the full court may currently be constituted, and if not an alternative, the remaining judges, which are 6 in number of the Supreme Court, who were not part of that 9-member bench, they may be, the bench may be constituted, and the matter may be referred to them to settle this controversy. This request was also not acknowledged and turned down by the 3-member bench. The other, of course, was the presence of the judgment handed down by senior punier judge, which directed office that cases involving question of under 184(3) may not be listed for hearing, and question was raised that in order to overturn that judgment, a judicial process has to be evolved, that a larger bench be constituted or matter be referred back to that bench for final adjudication, and it was not a matter to be dealt with by a executive circular. The honorable bench, the 3-member bench headed by Chief Justice, overruled all these demands or objections or requests, and finally passed an order whereby they themselves issued a schedule fixing 14th of May as the date for polling, and the different stages of election were also elaborated, and directed federal government to provide funds and security, which were actually earlier refused on multiple grounds, and Election Commission was satisfied with those grounds after examining the same, that the conditions were not conducive for conduct of election for multiple reasons, primarily the security, ongoing security threats and situation, and the incidents being taking place in KP and Punjab different occasions. Moreover, in the current financial budget, the allocation of funds was not made, and considering the economic conditions of the country, time and again elections and spending huge amounts were whether advisable or not advisable. This was also Election Commission. So they, in their own wisdom, they posted the date of election for 8th of October. The Honorable Supreme Court finally passed an order directing that no, this is no justification, the election be held on such and such dates. The government of Pakistan also took up this matter. The cabinet sought views of the legal experts during the meeting, the lawyers who were representing the political parties, and the principal law officer, the Attorney General for Pakistan. And the cabinet also resolved that it is a serious constitutional question regarding the original judgment which was handed down by 4 honorable judges rejecting the petitions, and minority view should not be implemented or imposed upon the authorities. and it would be in fitness of things that if at even that stage the court considers for referring the matter to a full court, barring those two judges who have already recused themselves. The matter was also discussed at length at the floor of the parliament, which is the proper forum to discuss important national questions, including any legal issues being faced by the nation or by the government or having strong nexus with the national affairs. And the National Assembly also passed a resolution in the meanwhile requesting the Supreme Court of Pakistan to consider under the law the propriety principle, the procedures, as well as the good practices, and to ensure transparency and independence, that the matter may be taken up in the full court. That resolution has also not been given any weightage by the court anyway. So faced with the situation, the matter is now under discussion in the parliament. To great extent, it's being discussed here and there. That's why I find it appropriate to come to you, answer your questions, if any. I just opened up the topic with basic history and details. So any question?
Azam Sahab, this is Nasir from CNN. I just want to know that, as we know, we have gone through the proceedings and your wonderful presentation today, briefing today. When we see the Constitution, there is no constitutional solution. Within the framework of Constitution, there is no solution. Then there is only one way left. You can't invoke emergency according to Article 232 because the President is there. One of your colleagues has attempted to give a solution which is yet a controversial solution, that government is thinking to file a reference against the three judges. So how serious this move is? Rana Sanaullah has said in one of his interviews that they are thinking to file it.
It may be under consideration, but there is no decision as yet. And I think that it may or it may not be an option for that. It has to be thoroughly examined and pondered upon before making any such decision, and that decision, of course, is to be made by the federal government, which is the federal cabinet. But so far there is no such serious move, with all fairness, I would say. However, as you suggested, there is no solution. No, there is a solution in the Constitution. Article 254 of the Constitution provides in unequivocal terms that if Constitution provides an act or a thing to be done within a stipulated period, and if that exercise or thing has not been done in that specified period, it would not be unconstitutional only for the reason that the same was not carried out in that stipulated period. Now, coming back to the instant issue that the elections are to be held in 90 days or not, the 90 days upper capping started, the period starts from 12th of January, which is actually the 90 days are being exhausted on 12th of April, which is around the corner, and in any way case the election have already been ordered. Whether that order is purely constitutional or legal, or whether it is executable or not, because of the controversy which is yet to be determined, whether it is 4-3 decision or it is a 5-3 or 3-member decision. So in the presence of 254 in previous events, at previous occasions, in 1988 the assemblies were dissolved the last week of May. I think it was 29th May, if I'm not wrong, by then President Ziaul Haq under 58(2)(b). 1988, when the Junejo government was actually dissolved by the President exercising its powers under 58(2)(b) of the Constitution. Now the elections were to be held within a period of 90 days. So the May, June, July, August. But the polls were conducted in November 16th, or November, at the exact date I recall was either 15th or 16th of November. So at that time a presidential reference was also sent to Supreme Court of Pakistan, because there were some issues regarding the expenditures, because in the meanwhile no budget could have been passed by the assembly. and the Supreme Court of Pakistan, invoking Article 254, allowed the expenditure as well as also indemnified the period which was consumed in conducting the elections, almost 5.5 months. Even in recent past, in year 2007, the assemblies, the National Assembly and provincial assemblies were to retire somewhere in the middle of November as well. So the Khyber Pakhtunkhwa Assembly, which was NWFP Assembly at that time, was dissolved in first week of October. And the rest of the assemblies, they completed their tenure in middle of November. So elections were to be held somewhere on or before 15th of January. In the meanwhile, Mohtarama Benazir Bhutto Shaheed, she was assassinated, and the law and order situation in the country was not so well and stable to go for elections. So Election Commission postponed the election without intervention of any court, exercising its powers vested in it under Article 218, read with Section 8 and Section 58, 7, 59 of the Act of today. उस वक्त उसमें 103 of the रोपा था. So elections were finally, I believe, held at the end of the February. And now you recall the KP Assembly was dissolved in first week of October. So their caretaker setup remained there for a period of 5 or more months. So it's not the first time, and that's why the Constitution provides a provision which covers these kind of situations and remedy the delays. Moreover, it is the Election Commission, to my understanding, which is the body under the Constitution to ensure that elections shall be conducted in a manner which is transparent, which is fair, which is just, which is independent, and where the corrupt practices are guarded off. Pakistan, as I earlier said, has a unique scheme under Article 2 to 4 of the Constitution, which provides the appointment of caretakers through a consultative process, a very transparent process, that leader of house, leader of opposition shall decide the name of the caretaker, head of the government in the meanwhile. If they don't agree, the committee consisting of 4 members from opposition, 4 members from Treasury benches, they will resolve the issue in 2 days, and if they fail, then the matter would be referred to Election Commission. This exercise was carried out in Punjab. There was no consensus. Matter ended up with the Election Commission with 5-0 unanimous decision. The caretaker chief minister was appointed. Likewise, unlike Punjab, in KB province, the outgoing leader of opposition and leader of house, they concurred on the name of Mr. Azam Khan, who is, and then the caretaker governments were lodged. My understanding is that if elections are conducted in piecemeal, that the elections in Punjab are conducted right now, and election in KP are conducted in somewhere in July or August, which is also, if we go by the judgment, it is also the violation of 90 days principle. Now, why court kept silent on it, and why court referred the matter to the appropriate high court, and why not Punjab? I mean, these are the questions which need to be answered by the court while sitting in the full bench. So then elections are to be held in KP in July, August. And finally, the National Assembly and 2 remaining assemblies of Sindh and Balochistan province are to retire or complete their tenure. I think it's the 12th of August. So then there would be elections before 12th of October. Or if in the meanwhile these assemblies are dissolved, then the 90 days period. So it's all mess, it's all confusion. We are also passing through very tough times. We are going through the economic crunch. The economy is at the worst right now for multiple reasons. The worldwide situation is also very alarming. Our security position is extremely worrisome. It's alarming in a way. There is a surge of terrorism in Balochistan and in KP. The entire army, which actually performs static duty, you know, 2,047 troops have been requisitioned by Election Commission to conduct election in Punjab and KP. It is almost half of the army. Now, they refused on the ground, what they've stated in the court, I believe, that they cannot deploy such massive amount of soldiers. They are extremely busy in the operations of the counter-terrorism operations. They are guarding the long borders of the eastern and western as well. So these are all the questions which can be answered if elections are conducted in a conducive environment and at the one and the same time, which is the scheme of constitution and law, and which we achieved after long deliberations. Like it took us 20, 30 years to reach to a kind of consensus that how the elections should be conducted and under whose supervision, and the watchdogs shall be appointed through an independent mechanism, same like the caretakers. The chief election commissioner and members are also appointed by the leader of the house and leader of opposition and their committees. I mean that they were appointed after reaching a consensus, so their impartiality cannot be questioned. So, keeping in view the entire picture, the government or the political forces belonging to the government alliance, they are of the view that there are few more issues. One is the ongoing census, which is also of great significance. We are spending 35 billion rupees on digital census. The last census were criticized by major political parties as well. They were not happy with them, and though it was decided in 2017 in the parliament by all parties that before the next general elections there would be a digital consensus and new constituencies shall be delimited after the census. Now the census is in process. It is likely to be completed. Some dates have been given in few weeks, and then there is another process. So what we are doing, we are heading for elections in 2 provinces on the basis of previous census, which was under clouds, and the rest of the country will have election on the basis of new census, the new delimitations, new constituencies, new dispensation. I mean, all this would be so confusing, and it will go on and on for all incoming elections. Every 5 years we will have an election year in Pakistan, which is also very expensive affair, I tell you. We are going to spend monies again and again. That is, conducting election in province and conducting election in the federation makes only one difference, is that you have to print one additional ballot paper to stamp for the National Assembly choice. Now, doing the exercise twice means that you are incurring expenses twice. The Constitution provides a room for all these things to be fixed under Article 254, and it should be in the best interest of the country for strengthening the political institutions, to bring more political stability, and to set the targets right for future governments to fight with the economic conditions and security conditions. The best solution is to go for elections at the one and the same time. But unfortunately, these matters were placed before the court. The government, the political parties, even the bar councils, those are the independent bodies, the impartial players. They also appeared at one point of time, as Azam might have been there, and they said that the demand for constituting a full court bench seems to be extremely appropriate and genuine, and the Honorable Chief Justice may kindly consider to accede to that demand, but for the reasons best known to Honorable Chief Justice, the demand was not acceded to. Yes, please.
Minister, I mean, it's true that the Supreme Court, the Chief Justice is seen as biased and the court itself appears polarised. But I'm wondering if disregarding this order might have bigger consequences politically. And I'm wondering what happens if May 14 passes without provincial elections in the Punjab? Like, how will the caretaker government still rule after that? And I'm specifically asking that question because people who are trying to mediate between the PTI and the PMLN have repeatedly said that this crisis is giving an avenue for other institutions to intervene and presumably acquire more power.
Thank you so much. So those were three different questions.
Thank you for your
Starting
patience.
from the last, starting from the last, I'm picking up first. Yes, we are passing through a situation kind of constitutional or political impasse, and this need to be addressed and this need to be fixed by the political forces. Or if not, the most appropriate forum was the Supreme Court of Pakistan, who was seized with the matter. The second part of your question is whether the Supreme Court is polarized or not. I don't want to comment on it. Every one of you know, you have seen different judgments. There are voices of dissent which are not being respected within the Supreme Court. And this was the high time, keeping in view the overall situation in the country, that the Honorable Chief Justice being the head of the court, being the head of, I would say, the head of the institution and the family, to unite it. I mean, the Supreme Court shall deal with these cases and announce their decisions in unison. So those are executable, having strong constitutional, legal, and moral authority as well. Now, what is happening that there is confusion in the legal minds as well, that this very decision, which revolves around fixing the date of the election, whether it is a decision given by 4 honorable judges, they stick to their stance and they release their separate orders, and they said that it is a decision by 4 honorable judges against 3. Their opinion cannot be disrespected in this manner. That one Chief Justice, in its own wisdom, says that no, I brush aside these dissenting opinions. Those are not dissenting, it's the majority view as a matter of fact. Reconstitution of bench, there are judgments by the Supreme Court, is not the prerogative of the Chief Justice. Once the bench take up the hearing, I mean, assumes the charge of the case. So that bench can only be altered if any one of them voluntarily recuse, which 2 honorable judges opted to. So it was a validly constituted 7-member bench. Out of those, 4 judges said that these proceedings are not maintainable, not proceedable in its present form. So yes, there is serious question regarding the legality of the decision, and that is why the government and the parliament thinks that it is not executable or difficult to execute. Now, what happens to caretakers? As I referred you in the past, the caretakers have been there for more than 90 days, like 4 months, 5 months, 5.5 months, under the same constitutional dispensation. The new scheme only changed the appointment of caretakers through an independent process and transparent process where the government and the opposition selects the caretakers. Rest of the things are in the same manner. And it is for the election commission actually to pass time to time directions. Caretakers carry on the government affairs to the limited extent, and for the rest of the decision they have to get permissions from election commission. Election commission enjoys all constitutional powers and authority, and under the law is empowered to run the affairs through the caretakers. They keep on directing them time to time how to run the affairs and where to stop and where to perform. So I don't think there would be any crisis after, if elections are not held on 14th of May, there would be any crisis-like situation regarding the caretaker government. For speaking for myself as a law minister, as a student of law, as a lawyer, I would say that again it is for the Supreme Court of Pakistan. Supreme Court can resolve this issue in couple of days if a full court bench is constituted. Those 13 honorable judges sit together, they examine all these issues and pass an order or a judgment which would be acceptable to all institutions and people of Pakistan.
Given the fact that the government has recently passed a law which is likely to come into force even if the president does not sign it, that is meant to clip the powers of Chief Justice, what government say democratize the Supreme Court. So it seems that under the new law, the government does have a right to go for appeal. So given that law, is government bound to implement the current order of the Supreme Court, or the government can wait until the appeal? Because there are speculation that the Prime Minister may be held or maybe convicted of contempt of court, the federal government, even federal ministers could be, summoned by the court and they could be issued contempt notice.
So can
Thank-
you please let us know what is your next legal course of action?
I am a trained lawyer. I spent 30 years in the courts. The lawyers never disclose their course of action, and I won't. Coming to your question, that the amendment or the passage of no law, it's not the amendment, it's the passage of a law which the Parliament is empowered to enact under Article 191 of the Constitution. The Supreme Court rules of procedure were also enacted under 191, and Constitution provides a room for the parliamentary intervention in that, like the enacting the laws to make the things straight or right. First of all, no powers have been curtailed. The powers still rest in the Supreme Court. When you read the Constitution, it is the Supreme Court. Nowhere in the Constitution it is said that the Chief Justice of Supreme Court shall pass such order. It is always the Supreme Court. The orders are always passed by the Supreme Court. The Chief Justice is first among the equals. So the Supreme Court right now consists of 15 honorable judges. The total strength is 17. The Supreme Court has to function, to pass orders, the judgments as a court. As rightly said by one of the honorable judges while writing his opinion in four-member order, that there should be no impression or perception of one-man show in the discharge of official or the constitutional functions of the court. It is the court which actually passes the orders and judgments. So the things have only been rectified or regulated on the basis of the principles of Constitution, that there should be collective wisdom should be given way to run the affairs of the court. We have not taken away a single or the slightest or weakest power from the Supreme Court. We are not saying that the cabinet ministers will constitute benches. We are not saying that the appeal against the Supreme Court shall lie before the Parliament or the President. Article 175 is very clear, which empowers the judiciary to perform its own functions. But at the same time, the Constitution provides that the Parliament may enact laws to regulate those powers, how those functions are to be discharged. And for that matter, these procedures have been introduced through the Supreme Court Practice and Procedures Bill 2023, wherein the long-standing demands of legal fraternity and even the senior jurists in the country and retired judges have been respected too. It has been time and again said that in order to check the I would say unregulated, if I'm not wrong, but to be more polite and to streamline the powers to exercise original jurisdiction in the Supreme Court, which is a very contentious matter for many years. We have seen that Chief Justices assuming office and then opening up a floodgate of original jurisdiction cases, suo motu cases. You have experienced those 2-3 times. Different tenures of the Chief Justice, and we have seen the Chief Justices staying there for years and years and exercising very sparingly in 1 or 2 cases. I've seen the judgments handed down by Supreme Court where they themselves said that this power should sparingly be exercised. I recall Chief Justice Tasadduq Jilani's era. He's a very well-respected Chief Justice. He took up 184, only one 184(3) matter that was regarding the rights of minorities in the country. I think that is kind of a case where we should say, or when you want to pass some order which actually enforce fundamental rights of a segment of society who have been deprived of, and the executive authorities are not listening to them. So in order to remedy the wrong, the Supreme Court can use that power, but not for this kind of settling the political issues or or transferring a government officer from one post to another, or many other occasions. We have seen the misuse of that power as well. So the law which has been enacted by the parliament has largely been appreciated across the board by the lawyer bodies, by the civil society, because of a long-standing desire. Constitution of Pakistan also provides right of fair trial being a fundamental right. Article 4 was already there, due process, that the no action shall be taken except in accordance with law and the constitution. But by introducing Article 10A in the 18th Amendment, we also ensured that it is the fundamental right of every citizen to have a right of fair trial in criminal and civil proceedings. Now, appeal is always considered to be continuation of trial. It is a fundamental right under the Sharia and under the Constitution as well. Why appeal should not be provided in 184(3) decisions which are being made by the apex court without recording of evidence, without fact-finding things, only on the floating facts. So appeal has been provided, a mechanism of distribution of cases, exercise of jurisdiction has been devolved in 3 senior most judges to ponder upon and to consider whether it is a fit case, so that the misuse of that 184(3) powers be checked with by the court itself. And yes, if the occasion so demands, if the right of appeal is provided when the law is enacted, the government has every right to exercise it, and we will consider at that time when the law comes into field.
Mr. Minister, somebody was talking about mediation. Is there any kind of mediation is taking place? Is there any chance for mediation, whether it is from Pakistan or maybe by the friends of Pakistan from other countries? And is there any chance that the government will be talking to the opposition, the PTI in this case? Is there any role of the election commission in connecting the government and the PTI?
Thank you very much. Very appropriate question. Being a politician, I believe in dialogue, I believe in negotiations. And good politicians always resolve their national issues, their internal differences apart. They sit together and they resolve their issues. The government is open, but unfortunately, the chairman PTI's previous conduct has been extremely negative, I would say, with respect and reverence, that extremely unbecoming of a national leader or non-cooperating. He never thought it appropriate to sit with opposition when he was in power. Bygones are bygones. We are open to it. The Prime Minister at one point of time also considered that yes, it can be pondered upon. However,